quickly?
Yes.
I'll be quick. Just the process for a police officer to show up at your house and seize your firearms, I think it's a much deeper process than what you described. They can't just show up to your house and seize your firearms. They need to have evidence presented against them, and again, it needs to be clear and convincing, which is a higher standard than preponderance.
Representative Swinburne.
Yeah, and in terms of that question, Representative Tesserman, if you'll go to page 9 at the bottom, it says when the order is vacated or ends without extension, that the licensing authority, if it has suspended a license to carry a loaded pistol or revolver, shall reinstate such license only after confirming that the respondent is currently eligible to have such a license. So there is...
But that would involve a next check.
Representative Welch. I recognize it.
That was what my complaint was. There's no way, once I report it to Nix, it's fixed forever, get your name off. And it could be done. It can't be done under this code, put it that way. It would be disarming that individual for the rest of his life.
Representative Burke.
Thank you, Mr. Chairman. This is for Representative Pearson, if I said his name right, hopefully.
I don't have a name tag.
All right. I've looked in this, the bill, not the new amendment that we just got. Could you show me where a person that cannot afford an attorney will be issued an attorney by the state?
Representative Pearson.
Thank you, Mr. Chair. I can't, and because this is a civil matter, right? So this is a civil matter of that's under the threshold, the constitutional threshold that would require right for representation by an attorney. So I think that's a good point that you brought up, that this isn't a criminal matter. These protection orders, of course, if they violate this, then that would, just like a civil restraining order, that would then go into the category of a criminal offense. But as it stands right now, this isn't a criminal action, and that's why there's no criminal record associated with these orders or anything to that extent.
Representative Adams.
Well, I agree, the right to counsel doesn't apply in a civil case, so there's no constitutional right to have counsel appointed to you in a hearing like this, unless we expressly put it in the RSA ourselves. I would just point out a couple issues with the bill itself. That, one of the issues is that if this order were to issue and then it would expire based on the petitioner not asking for it to be extended, the order itself is what resulted in an individual having to surrender their firearms. But once the order is gone, their property is not returned to them. The order is, although no longer in effect, you're still being impacted by the order itself, even though the order is expired. Now, there are provisions in this, I haven't time to finish reading the most recent amendment, but I assume that's still in there, that if the petitioner wants this extended, they have to go into court within a certain time period. I believe it said 30 days when it's going to expire. However, if it does expire, then the respondent has to go into court to get their property back. And one of the things they're going to have to show is that they are eligible to be able to have a firearm or be able to possess a firearm. If there are federal laws that are in place that are preventing that person from doing so, even though this order is gone, they're still not having their property returned to them. And that's one of the problems, just from an efficiency perspective, that also, if you want to file that motion to return your property, you got to then give the petitioner notice, so they have a right to appear at the hearing, even though that petitioner chose to not have this extended, or to not file it to have it extended. And that petitioner then can appear in court again at that hearing asking that it be extended. To me, there's a lot of, just from my procedural perspective, that's as inefficient as it can be. If the petitioner's not asking for something to be extended, I'm not sure why they would then show up at a hearing where you're trying to get your property back to have it extended. So these are things that I would like to work on, but it doesn't seem that based on the motion that's made, that's something the committee wanted to do. I know I had a conversation with some of the members in this committee in private, and I was willing to work with the committee on trying to get this right and try to put the best bill forward. I agree perfection's a high standard to reach, but I would hope we at least tried to get there, and I don't think this does that. I think that this is something that once it's issued, even though it's no longer operational, it's still going to impact the respondent. And I think that's a concern that I have with the bill. And I think that we should focus on implementing this the best way possible, because we are dealing with someone's constitutional rights. And if they are going to be impacted, we should at least try to tailor that in a way that it doesn't, it's the least restrictive on those rights as possible. And I feel that as a committee, we could all work and get there together if we try. But I hope we reconsider the ought to pass and actually retain this to work on it. And I'm willing to work with you on this. And I've said that before the hearing.
Representative Down.
Thank you, Mr. Chair. This bill, I put a lot of work into this bill, reading it, and a lot of things that were said at the hearing, I looked in and I actually took out the Constitution, and yes, the Second Amendment is important, but the 4th to the 15th, some of those rights are also being violated in this bill, and I never really have taken out and studied the Constitution, but if you look at it, everybody always brings up the Second Amendment, which is important. Every one of them is important. Our founding fathers put those amendments in there for a reason. And they work bipartisanly on things, so I think the best choice would be to retain the bill and work on it as a group and see what we can do.
Representative Wallace and Representative Welch, and then I think we might.
Thank you, Mr. Chairman. Representative Pearson, we all agree that this is a civil proceeding, and I quote the New Hampshire Constitution, Article 20, "And all controversies concerning property gain and all suits between two or more persons except those in which another practice is and has been customary, and except those in which the value in controversy does not exceed $1,500 and no title to real estate is involved, the parties have a right to a trial by jury. This method of procedure shall be held sacred, unless in cases arising on the high seas and in cases relating to mariners' wages, the legislature shall think it necessary hereafter to alter it." What say you?
Representative Pearson and then Representative.
So that's about jury trials, right? That's not about, you're not asking about whether or not someone has a right for an attorney, right? Just for clarification, I'm curious what exactly you're
We're
asking.
talking about property in excess of $1,500, you have a right to a jury trial.
Yeah, if that is indeed the case, but again, I think that this acknowledges that these hearings take place in front of the Superior Court, and they could request a jury trial if they wanted. I don't think that this skirts around that constitutional provision at all. Again, I think that this is constitutionally sound, both the state and the federal constitution.
All right, I'm going to recognize Representative Testerman, and then we're going to try to proceed to vote on the amendment. Representative Welch.
I had a request.
Then Representative Testerman, Representative Welch. Is there anyone else who wishes to speak after? Representative Gaffney, then Welch.
Croc TV.